Can I leave my villa down in Estepona to my son and my daughter-in-law? I love my daughter-in-law dearly, and I want to make sure that she's aware of how much I loved her and how much I wanted to look after her. Okay, so can I do this? Yes. Is it in their interest? Maybe not. My name is Michael Davies. I'm a Spanish estate planning lawyer, and I've been helping expats with estate planning and probate all over Spain since 1994. That's over 25 years now. Okay, so in this case, yes, you can escape the Spanish system of obligatory heirs and leave, if you're English, things to whoever you like. You can leave things, all the things to the cat's home if you want, as long as you do have to make a Spanish will stating that you, conforming to Directive 650/2012, you choose English law to determine how you can distribute your estate. You can then go on to do whatever you want with your will. Okay, so in this case, though, is it in your interest? Let's work it out. If you, in Andalusia, you left the complete villa to your son, that estate, he will pay no inheritance tax. If he will pay no inheritance tax at all if what he receives is under 1 million euro. Okay. Now, if on the other hand, you decide to leave it jointly to your son and your daughter-in-law, you need to be aware that your daughter-in-law is going to pay quite a lot of inheritance tax on the share that she has received. So you haven't given me a price, but let's say that it was 800,000 euro, and therefore what would happen if you left it jointly to your son and your daughter-in-law? Okay, well, your son wouldn't pay any inheritance tax on his half because it's exempt up to 1 million euro, and your daughter-in-law, she's a group, your daughter-in-law on 400,000 euro, she will actually pay, on 400,000 euro, your daughter-in-law will pay about 120,000 euro in inheritance tax. Okay, so the difference is tremendous. In other words, if you leave everything just to your son, no tax. If you leave it jointly between your son and your daughter-in-law, there'll be a bill of 120,000 euro. Why? Because in Spain, it's each beneficiary that has to pay inheritance tax or declare inheritance tax, and they pay more or less depending on their family relationship with the deceased. The closer you are, the less inheritance tax. Okay, so in this particular case, you may still want to do it at the end of the day, but if there is any other way of you looking after your daughter-in-law, it will be better. For example, if you have assets in the UK and she is a resident in the UK, maybe it's in your interest to benefit her with assets in the UK and not with assets in Spain. If your daughter-in-law was resident in Spain, then it would make no difference because in Spain she'd have to declare what she receives worldwide. But if she's a non-resident of Spain, she would only have to declare what she receives in Spain. So I'm not saying don't leave anything to your daughter-in-law, but you do need to be aware of the consequences, and I'd say look to see if there's any other way of achieving what you want without having to pay such a large inheritance tax bill. Okay, so again, I'm Michael Davies, Spanish estate planning lawyer, been in practice for over 25 years. If you need help with estate planning or probate anywhere in Spain, please contact me. If you like the video, please hit the subscribe button, and I hope to see you in another video shortly. Thank you.